Are you?
I'm great. Thank you so much for having me. And don't let it be fooled, our 59 and sunny, we haven't had rain for a month. And that's a
Oh,
big deal here because we burn every year now. So
right.
we we wish we had everyone's weather that everyone else is experiencing.
Yeah.
So thank you for having me. I am an estate planning attorney in California. That ubiquitous term, estate, it really just means what you own. It doesn't have anything to do with the size of your assets or the dollar amount or anything of that nature. It's just one of those words that came over from, fancy schmancy English estates in the countryside. It doesn't mean anything like that now. So I promise you that everything pertains to everybody in this group. And we'll just kind of go through. I'm going to talk about the top 10 questions that we get in terms of planning for your legacy. And so we're going to go through, and if you have any questions, please ask them. So let me do that. Okay, perfect. So our top 10 legacy planning questions. The very first one is, do I need a will or trust if I don't own real estate? A lot of people think that if they don't have enough assets or they don't own their own home, do you still need a will or a trust? And the answer to that is it depends. So that's the big lawyer answer all the time. It depends on your personal situation. But if you do have items, whether it be a wedding ring or a family heirloom that you want to be passed down to somebody in particular, you should have at least have a will. In all 50 states, everybody has a will. Every state has their own will process. Almost all of them have a probate process, which is just a court supervised process to make sure that your wishes are fulfilled per your documents. A trust is something that's set up a little bit different, and that could be very specific as to what you need, but it also avoids probate. So it avoids that court supervised process. So it just depends on the laws in each state. Unfortunately, every single state in the US has different laws regarding their estate planning, but there are a lot of concepts that are generally the same across the board. So we'll get through the majority of those. So don't let the term, a will or trust be a big scary document. It's really just a mechanism for you to plan what you want. Number 2, who will manage my assets if I am unable? If you ever become incapacitated, whether that be something as serious as dementia, or if you so much as go in the hospital for a few weeks and you don't have access to your checkbook to pay your bills, nobody can do that for you unless you have what's called a power of attorney. And that's a document that allows someone to step in your shoes legally and financially, and even medically, to make medical decisions for you if you cannot, but mostly financial and legal. So if something happened to me, I'm married. That does not mean my husband could step in and handle assets that just have my name on it. He would have to have a document that I would have signed prior saying that he's allowed to manage my assets if I'm unable. Most states have what's called a statutory power of attorney that you can download from the state. You usually just fill it out, name who you want to name, check the boxes for the powers that you want to give them, and then you sign it in front of a notary. Not all states have the statutory version, but you can always download something online through LegalZoom, or you can meet with an attorney. It depends on your situation. If you do not have one of these documents, the only option for someone else to get access to your finances to help pay for your care is through a conservatorship or a guardianship. And that's, time consuming and expensive. And then to kind of follow along with that is who's going to make medical decisions for me. There's a lot of different names for these documents, so I'll kind of go through them. You have a power of attorney for healthcare. That's the document that names your agent, names who you want to make medical decisions for you. You'll also hear about what's called a living will. That is your actual wishes in terms of what kind of medical care you would want. And then in some states, like in California, we combine those two documents and call it an advanced healthcare directive. A lot of times your medical provider can provide these to you. For example, in California, Kaiser is a huge insurance company, and they have their own power of attorney for healthcare or advanced healthcare directives, and they provide those for free. And a lot of times they do the notarizations for free in the hospitals for you. There are Other documents that you can use to go with that, there is what's called a DNR, or a do not resuscitate. That is a document that you get from your doctor's office, and you can fill that out. It's a little black and white in terms of there's not a whole lot of options built into it. But as you'll see on the screen, there's a hot pink sheet. That's typically what people refer to as a DNR, but it's not. It's called a POLST, a POLST, or Physician's Orders for Life-Sustaining Treatment. And this is the same concept as a DNR, but it's for very specific situations. So it's not, if I fall down and have a heart attack today, do I want CPR? Yes or no? At my age, yes, of course, I'd like CPR. But if I have a bunch of underlying health conditions, or there's different criteria that might be on this form that would make me say, no, I don't want it, that's when you would fill this document out. And you fill this document out with your doctor so that they can explain all of that for you. You don't want me as an attorney explaining your medical chances to you. You'd want your physician to explain that to you. And these are provided at your doctor's office or hospital. They will fill out the forms with you. You often see them outside people's doors in the hospitals, or people keep them on their fridge because paramedics somehow universally know to look there for forms like this. They have to come to your house. But it's very important because, again, same with power of attorney for finances. If you don't have someone who's going to make medical decisions for you that you've named in advance, sometimes the hospitals will allow your next of kin to make that decision. But if there's ever any conflict, somebody's going to have to go to court to be named as your medical power of attorney. I don't know. I'm sure some of you recall that case in Florida of Terry Schiavo from the 90s, where she went into a coma and, was technically had no brain activity, and her husband stood to inherit from her if she passed away. And her parents knew that, and her parents wanted to keep her alive, and her husband wanted to pull the plug. And it became a huge, long, drawn-out court battle, which I'm sure she did not appreciate, that she didn't have any say in the matter. And she was very young. It was just one of those things. We get clients like that who don't plan, and then it leaves their spouse or loved ones to have to deal with a little bit of a tangled web that they have to unweave. Okay, what will happen to my pets if I can no longer care for them? This is a gratuitous photo of my dog to throw out there for everybody, because who doesn't love a good dog picture? If you can't care for your pet anymore, and you don't have someone who can step in and care for your pet, it kind of depends as to what's going to happen, but the majority of the time they are going to go to the pound. And most people don't want that. I don't know about where everybody else is, but in California, our pounds are high kill shelters, and we don't want our pets to go there. So the best thing to do is to have somebody in mind that would be willing to take your pet. If you don't have that, you should work with a local rescue like the Humane Society or ASPCA. And a lot of times, if you sign up with them in advance, they can help you rehome your pet. Either if it's something after you passed away, they'll do it for you, or sometimes, if you have to move into assisted living and can't take your dog with you, or things like that, or just moving from apartment to apartment, you have to go based on your needs. Sometimes they don't take pets. So a lot of times rescues will work with you in terms of rehoming the pets. Let's see. Okay. So I talked about it briefly, but what is a trust, and isn't that only for the wealthy? So a trust sounds fancy. It's really just a basket that holds your stuff and prevents it from having to go to court when you pass away. It also helps if you ever become incapacitated. The items in your trust can be handled by who you name as the successor trustee to your trust assets. So for example, if you own your house or you have a bank account and you put them in your trust, if something happens to you and you're incapacitated, you've already named somebody in that document that will take over and assist you if you're incapacitated. You maintain that you're the beneficiary of your trust. So the person's job is to step in and help manage your finances. Once somebody has passed away, the trustee is then there to manage the assets for the beneficiaries and make sure that it gets distributed accordingly. If you own your home, this is really important. If you have multiple people that you want to leave things to, or charities, this is important. There are other ways that you can leave things to people without setting up a trust. So it just kind of depends on what your wishes are and what mix of your assets are. If you have a very complicated, you got a really full jewelry box or some furs and you want to make sure they go to certain people, then having a written trust or will is a great way to make sure that that happens. All right. This is always the big question. What happens to my bank account if I pass away? Like most of us, we have a checking and a savings account, and that's pretty much it. So what happens if you were to pass away? If you do not have anybody on your bank account with you, meaning it's not a joint account, or you don't have a beneficiary listed on the account, then it goes according to what are called the laws of intestate succession. I know, fancy words. The laws in all 50 states, if you die without a will or a trust or a beneficiary, they say who gets your stuff. Most states, I think, are the same, but typically it goes down. So if you have you, and it goes down to your children, if you have children, or grandchildren or great-grandchildren. If you don't have any children, or what we would call descendants, then it goes back up to your parents and down to their children. So your siblings, some states half siblings count, and then nieces and nephews, grandnieces, nephews, etc. And then even then, if you don't have any siblings, it goes up to your grandparents, and then down to your aunts and uncles, first cousins, and so forth. And it just keeps going and going and going. So if you don't want that, for instance, you would want to make sure you have a will or a trust or a beneficiary designation that lists who you would want to receive your belongings or your money after you pass away. Okay, should I add my children onto my bank account? So if you have one child, that might be something to think about, but there are multiple issues to talk through with this particular subject. So adding any of your children or even a friend onto your bank account means that in the eyes of the law, that account is now the asset of that person. So if your daughter is getting a divorce, that is considered an asset available in her divorce. If your son gets into a fender bender and someone sues him, that account is now considered an asset that they can collect money from, even if he never put a dime in that account. Because when you add someone's name onto it, you're essentially gifting it to them. So you don't want to necessarily do that. In addition, if you have 4 kids and you add the oldest daughter on because she's the one that's helping you with everything, and you pass away, it all goes to her. She's not legally entitled to have to share with her siblings. It is her money. That may be what you want, which is okay too, but it can cause some contention amongst siblings, just to be aware of that. But essentially, that is considered an available asset to whoever's name you put on it. If anyone needs to apply for government benefits, any type of Medicaid, food stamps, anything like that, then it would be counted against that person, even if the child doesn't look at it as their money, they look at it as yours. So those are all things to think about. It might just be specific to your particular situation. Okay, what happens to your retirement accounts or life insurance? A lot of people just have their normal checking account and they might have an IRA that they draw off of in retirement and their Social Security. With retirement accounts and life insurance policies, they have what are called beneficiary designations, and that would be a form that you fill out with that company. So if you have a, an Aflac life insurance policy, then you would fill out a form with Aflac for that policy to fill out a beneficiary designation. If you have a Wells Fargo or Morgan Stanley IRA, you would want to make sure that you fill out that beneficiary designation for that account with Wells Fargo or Morgan Stanley. The beneficiary designations usually have you name a primary beneficiary and then a secondary beneficiary, or sometimes known as a contingent beneficiary. And that means if the first beneficiary does not survive you, they pass away before you, then they go to the next one. And these are important forms to keep up to date. If you've had the same beneficiary designation for 20 years, you want to contact your IRA custodian and confirm that they still have a beneficiary designation on form for you. They do go missing from time to time, and they don't deem themselves responsible for maintaining that information for you. So that's important. And a lot of times they have their own rules. So if something were to happen to you and you didn't have a beneficiary designation listed, it may be something that has to go to probate, but it may be something that they have their own rules as to who would get that. In terms, not like a random person, but it would be, one of your family members, things like that. So if most people do, if you feel strongly about who should get that, you want to make sure your beneficiary designation is up to date. Okay, what happens to my belongings? This is everyone's favorite. What about your book collection, your jewelry, your family photos? What happens to all of that? That is up to you. You get to put that in a document, in a will, that says where it goes. And a lot of times you can just list it out. I know I've heard of some popular methods like the Post-it note method, where you go stick a Post-it notes on everything with who you want to get it. I promise a will is a much better way to handle that. And wills don't have to be something that you draw up with an attorney. In addition to statutory powers of attorney, a lot of states have what are called statutory wills. And that's something that you can download and fill out. In all the states, you can handwrite your own will. You just write it all out. It's called a holographic will. Those are usually the hot topic in books, like a John Grisham book. So it's someone's handwritten will. One of the things you can do also is you just would want to double check how a will should be what's called executed, which means how it's signed. Typically, you would sign it not with a notary, but in front of a couple of witnesses that would sign their name to it as well, confirming, you're over 18, you know what you're doing. And they should not be people that are named in your will or that stand to inherit or that are related to you. So you'd want your neighbors or a friend or somebody of that nature to be able to sign off on your will. It varies state by state, but that's generally an accurate statement, is two disinterested witnesses witnessing you sign your will. And then our last question is, what do you do with your digital assets, and what are your digital assets? So now that times are different and we keep, who develops film anymore, you have pictures on your phone, on your computer, your Facebook page, any other social media you might have. If anyone's got Bitcoin out there, things like that. Those are all things that you own, but they're not tangible, right? You can't touch them. They're on a computer somewhere, in a cloud somewhere, in your phone. How is someone going to access your phone after you pass away, or your Facebook page after you pass away? So it's important to either have a plan with your provider, let that be an Apple iPhone. How is someone going to access your phone if they don't have the password? How are they going to access your Facebook page? There's something that you have to set up within Facebook in order to have that planned out. But also, if you were to have a trust as a part of your estate plan, that is something that can be handled in that way too. There's usually a provision in most revocable living trusts that set up your digital assets and provide somebody access to your digital assets. And that is it for now. I see we have questions in the chat, so I'll let Nicole.
Yeah, so we definitely have a bunch of questions, and I'm sure we'll get some more as we go on. So if anybody thinks of anything during when we're answering these questions, please chat them in, or you can use the raise hand button or just wave and we'll get to. So Rose, I saw you had a bunch of questions, and I saw that if you want to can unmute Rose. We could stop sharing screen so we could see everyone. And then, so Rose had a bunch of questions. One of them being, is a trust just like, is it a will?
Yeah, so a trust it's a little bit different than a will. And for lack of sounding morbid, in order to avoid probate in America, if you have a will and that's all you have, it's still going to have to go through this probate process. Some states have a short version, some have a longer version. In California, everything's longer and takes twice as long and costs twice as much. So a trust is its own entity. So it's something that you form, obviously, while you're still alive and you know what you want. You put everything in the trust and have the document ready to go. And essentially, it holds everything. And then once you pass away, it becomes its own entity with its own taxpayer ID. Like, it doesn't use your social security number. It doesn't have to go through court. It's kind of like forming a business in that it holds all these assets or whatever you put in it. And then the next person in line gets to go ahead and access it and do what they need to do with it. That doesn't require any court involvement. Whereas a will is definitely going to require, the goals are the same. The goals of the documents are the same in terms of you get to decide where you want your stuff to go. But how it's done is a little bit different.
And do you need an attorney to make a will, or can you write it down yourself, or the forms online, which I know someone else messaged about that they were, Marilyn McNair actually asked, there are forms online to print out and sign. Are they legal? So I guess that could be sort of a two-part answer
so
there.
For a will, you can definitely do that on your own. You can either just handwrite the whole thing and sign it yourself, and then you can, to always be extra sure that it's admitted by the court, you have two witnesses sign off on your handwritten will. You can download the forms. Some states have statutory forms. You can do like LegalZoom. You just want to make sure it's state specific and that you get the instructions specific to your state as to how you're supposed to sign it. That's the big thing, is like whether there's supposed to be certain language that the witnesses are signing to, which in California we have what's called an attestation clause. And that's saying essentially you're putting your hand up and saying, I swear that Nicole is signing her will in front of me and she's over 18 and she knows what she's doing and she's of sound mind and I know who she is and I'm going to sign off on that.
So does that need to be notarized, or do you need to?
Not typically, although some states may have a notarization requirement, but I'm not aware specifically of any. But that's easy enough to find. So if anyone has questions, I can always find that.
Okay, because I saw, Rose, you had asked if you needed witnesses to validate the signature, so we're clear on that. And then where should one keep a will, and do they need to have someone have a copy of the will if, let's say, she wrote it or even printed it out, or it's right in her hand there, there's her, that it right there, yellow and blue.
Yeah, I definitely recommend you just keeping your original will. I don't recommend a safe deposit box just because getting into those is a pain after somebody passes away. So I don't suggest that. Just a safe place in your house. If you, obviously, if you have an attorney, you can keep it at the attorney's office. Whoever you name as your executor or beneficiary, you could leave a copy with them as well. What will be required typically is that the original is what gets filed with the court. And if you can no longer find the original, then you have to jump through a bunch of extra hoops in order to file a copy. So whatever the safest place to keep that original is for you.
Does that help, Rose?
Yes. I mean, and I have like my funeral papers that say my space is paid for and so forth, and I'm still paying off getting my cremation, but I'm just wondering, should I put the will with the funeral papers?
I think that's a great idea. I think having everything as organized or together as you can for whoever is going to be handling everything makes it a lot easier.
It makes it really hard for me because I have no children. My husband has already passed away.
Yeah.
Oh, you're right on mute, Rose. Hang on one second. Hold on, Rose, if you want to unmute. Sorry. So
Yeah,
we heard, yeah.
Health is not real good. In fact, I'll probably outlive them. So I just wonder,
So who would get that, Madison? So she has no children, her husband passed away, she has a sibling, you said? That's the part that kind of got.
Yeah,
uh,
I have a brother and sister,
Yeah.
but they're both really ill and they may pass away before me.
So
I'm a lot healthier.
just to clarify, is the question who would handle that for you or who would receive everything?
I'm wondering who should I give it to, you know,
Yeah. Do you
in
have
case.
do you have an idea of who you want to receive your stuff after you pass away, or who you want to handle that for you? Who's going to be in charge?
Mm, I have a couple of friends, but you know, other than that, no.
Yeah, so you can always provide copies to them. You may be able to lodge your will technically with the county courthouse where you live. You might be able to do that while you're still alive. It just kind of depends on the county and the state in which you live in. So sometimes that's allowed. But
Okay.
essentially, there are some companies, I shouldn't say companies, but nonprofits that handle after death or even incapacity planning for people. So we have some where they have like professional fiduciaries involved where, for some people they charge for their services, but then that makes up for the pro bono work they do for other people to help manage their estates or their assets. So that would be something that you could look into. You might be able to find something through your national or your local council on aging or your local national aging in place council. If there's a nearby chapter, those are all resources that you could look into for that if you need someone to handle it for you. And then if you're leaving anything to charity, sometimes you can name the charity as your executor or so forth, and they can handle it for you, just depending on how your will is set up.
All right. Thank you very much.
You're welcome.
Okay. Okay, so Gail Kearney had, it's in the chat, one of my adult children will inherit her share of my estate when both my husband and I pass away. The state of her marriage is unsure. If she is still married after we are deceased and she gets a divorce, then her husband will be entitled to her inheritance. Is there anything I can do now to prevent this? She does not have a prenup agreement.
Yes. So this is a little bit different because every state's different on that. So if you are, if a spouse is entitled to somebody's, what we would call separate property, meaning it's an inheritance, that in California, that's not considered community property. So a spouse would not be entitled to it, but you can set that up in a trust. So if you were to do you and your husband would set up a revocable living trust, and her inheritance would go to her in a trust. So it would be separate. She doesn't have to put that in a joint checking account with her and her husband's name on it or anything like that. It just stays in trust for her, and then she can access it, but she wouldn't necessarily have to pull it out of that trust until after her divorce is final, or there's a date of separation, whatever the law goes by in terms of separating that.
Does that help, Gail?
Yes, it does. Thank you very much.
Okay. I'm going to go to another question here, and I do see a couple hands up, so we'll get to you in just a moment. So Pam, you have your hand up, and I do see a question, so I'll unmute you as well. Pam asks if beneficiary is 50%, is 50-50, and one of them pass away, would the second get the full 100% automatically, or could there be issues?
So it's going to depend on the beneficiary designation itself. A lot of times when you put two people and it says two people equally, or the phrase or the survivor of them, then yeah, the survivor, if out of two, one passed away, the survivor would get 100%. It's going to depend very specifically on the beneficiary designation and what that company's rules are. Sometimes they will say, oh, if somebody dies, then it goes to their family or their children. And sometimes people don't want that. If you're naming like your best friend as a beneficiary on your IRA, but you don't want their kids to get anything if they were to die before you, you would want to make sure that that's up to date and that you're clear on that with your beneficiary designation. The good thing about IRAs and and things of that nature, is that there's always some person automatically assigned to your account, listed as your financial advisor. You might not know who they are, but there's always somebody that you can call and contact about that's assigned to your account number.
Does that help?
Okay, so
Yeah.
yes, it does. So I have to ask the bank specifically on the form I filled out what their rules are.
Yeah, and you might know based on looking at the form. It just depends on what the language on the form is. If it says to two people equally, like, then yes, if the survivor of them will get 100%. If it's set up via, 50% for one and 50% for the other, there's usually another box somewhere that says whether or not that lapses. If somebody dies before you and their share lapses, then it goes back to the other person, the other beneficiary. If it's blank, or that usually means it would go to their children.
Okay. So I raised my hand for another question. My parents were divorced a real long time ago. My mother remarried quite some time ago. So there's a blended family there. And so all of my mother's assets are now mixed in with my stepdad's assets. And we need to go to an attorney. I'm wondering if there's any resources to find out, to ask my parents questions ahead of time, because there's kind of like, do the stepkids get anything if my stepdad passes first, or do me and my siblings get anything if my mom passes first? Like and of course there's always family drama are in this mix as well. So I'm trying to get us prepared as well, so we're not spending so much time at the attorney's office.
Yeah, I think that's great. And I think that, it's gonna require some participation from your mom and your stepdad, but I think the way that you phrase it to them matters. And a lot of times you can find an attorney who will do a consultation for a nominal fee. We like to call them family meetings. And I think the best way to phrase it to your mom would say, we don't want any surprises, that's going to cause some dissension or ill will among siblings. So we just want to make sure we're all on the same page and understand what's going to happen, and that what's going to happen. Because a lot of times people's trusts are set up such that, it's to protect the first spouse that passes their children, and they can be set up for blended families. So either they don't know that that's available to them, or things have just changed, because the estate taxes have changed so much in the last 20, 30 years that people might have very antiquated trusts that don't work for what their goal is. So I think if you were to ask them to have a family meeting, just so an attorney can review their trust and make sure it's up to date, and everybody wants to know what's going on, so that there's no surprises. No one thinks that whoever's going to be in charge is trying to swindle their siblings out of an inheritance, things like that. If you could bring that up to them in that way, just making sure, that there's no surprises really. And an attorney will definitely review that for you.
Okay. My stepdad is older. He's in his 80s, and they have not done a trust yet. I've heard that a trust really isn't fully in effect unless it's been effective for like 5 years or something. Is that?
That's not something I've ever heard of. Typically, a trust goes into effect the day you sign it. And then, of course, once you have to retitle your asset to go into the trust, and that's how that would work. So like if they own a home, they would retitle it. Instead of mom and dad, husband and wife, it would be mom and dad trustees of the mom and dad trust, or whatever the case may be. And a trust is a great way to affect, what you're worried about, to make sure that everyone's either treated equally, or, that it's all set up such that people don't get more or less just because their mom or dad died first or second, and that you can set it up that way. A lot of times you can set it up so that if your mom died first, you get something, but is depending on what they have, do you want that to be taken away from your stepdad when he might need the money too? So there's a lot of things to go over specifically, and I think that's a great idea would be to set up a trust, because if they don't, then sometimes it means whoever the last one standing is gets to make the decision. And that sounds like that's not what you're looking for.
No, is there a resource I could go to like have all these questions? So I can kind of talk my parents through it.
Sure.
And then go to an attorney, so they're not feeling like, they have to answer right away while the attorney's sitting there.
Yeah, I can't think of a specific resource in terms of what you would need to talk to them about, because a lot of it is specific to what your parents own.
Yeah.
I do believe we have some blog posts about it on our firm website, which is at absolutetrustcouncil.com, that are pertinent to having a family meeting and making sure everybody's on the same page.
Perfect.
And AARP might have some as well.
Perfect. Thank you so much.
Okay, so I see a bunch more hands up, and there's a bunch in the chat. So I'm going to pause on the chat. I'm going to go to Anna, and then I see you, Rose, and Marguerite. I do see you as well, and Jen. So we have questions coming in both ways. So I want to get to everyone's questions. So Anna, go ahead.
I want to know if I could ask you about the living will.
Okay.
I designated somebody who moved. Do I have to redo the will?
If you don't want them to be your
Oh,
agent,
I want them,
Yeah.
but they moved and their telephone number and address changed.
if the phone number or address changed, you might be able to just add, you can either redo it, or you can just add a piece of paper on the back that has their current contact information.
Okay, so no notarization, nothing.
No,
Thank you.
because as long as their name's the same, that's all that matters.
Thank you.
Okay, and I do see Marguerite. Go ahead. Hold on, we're just going to unmute you if you want to. Yeah, go ahead.
Still
No,
muted.
you just need to unmute. There you go.
Okay. All right.
Yeah.
I want to know how you decide between a trust and a will. Does it have something to do with the dollar amount? Like if you have over 2 million, you ought to do a trust, or under 1 million, you ought to do a will? How do you decide between a will and a trust?
Yeah, I think that it really depends on not so much the dollar amount, but how you have your assets. If you have everything in a brokerage account and IRAs, and you can put beneficiaries on it, and you're okay with that, meaning you don't have 10, 12 beneficiaries. I mean, once you get your beneficiaries get complicated, or if you want control, more control, then a trust is better. If it's just leaving everything via beneficiary designations, and really the only thing you need to parse out is maybe the contents of your home, then a will is probably the best. And if you own real estate, you would want a trust.
Okay, I have a little bit of both, and I have 3 children and 8 grandchildren.
Yeah.
So does that sound like I really might need a trust then rather than a will?
It sounds like it. Yeah, you can be much more specific with a trust. So you could say, let's say, for example, you want to leave everything to your 3 kids and that's it. But if one of your kids should pass before you, heaven forbid, you'd like their share to go to their children, and it be managed by a trustee. If you want that, then it would need to be in a trust. If it's a will, then the court is going to set up something different. They're going to say if one of your children passes away, you now have to have this, you have to get a court ordered guardianship to have someone receive money on behalf of your children. And then it's going to go into a blocked account that can't really get access without court approval. There's much more hoops to jump through with a will than there is with a trust.
What if you have a will and then you have a notebook and you say, I want this jewelry to go to this daughter, this jewelry to go to this other daughter, these art paintings to go to somebody else, just in a notebook for your children to read?
Yeah, if you are 100% certain that your kids are going to be okay with that, then that's fine. It's not a legally binding document.
Okay, so if they can test any of that, it's not legally binding at all.
Correct.
Okay.
Yeah.
Okay.
So I mean, it's different if you have, some paintings versus, a Norman Rockwell or a Monet in your house. That might be,
Well, I don't have
none of us do, but that's,
Right.
those are the differences where they might be more contested. But also I've seen people go to court over sentimental value.
Mhm.
Yeah.
So, I mean, it's just going to depend. I'm always going to recommend that you, depending on what your assets are, I always recommend, setting up a trust. You have much more control that way. You can set it up with provisions so that if one of those grandchildren ends up maybe being special needs and needing public benefits because they're autistic or on the spectrum, then that can all be built in so they don't lose any benefit. You have a lot of control with the
Okay,
trust.
so you're really leaning more towards a trust rather than a will.
Correct. Yeah.
Sounds
And to be clear, you still have a will when you have a trust. It's just
Oh.
much shorter, and it's what's called a pour over will. And that means the will says, I, Marguerite of, wherever you're from, and it says, I leave everything to my trust. And so it helps catch those things that may be outside of your trust, or if there needs to be, something what's called poured into your will. It's set up so that you can do that. It's supposed to be foolproof so that there's different levels of protection. The trust being where the end all, where everything ends up, and that then distributes everything.
So you can have a will as well as a trust, and then you could also have a notebook with some things written down
Yeah.
there too.
Yep.
Oh, I thought you needed to have separate thing. Okay.
No, it's usually a very comprehensive estate plan when you set that up. And in fact, for us, the way we draft our trust and it might be the same, everywhere else, is we have what's called a personal property memorandum. So we have our trust that we draft for you and you sign, but then it has a blank list so that you can do that jewelry and art and books and things like that. And you can update that over time without having to consult the attorney every time you want to make a change.
Okay. And the same with a brokerage account then. You could decide in my brokerage account, I want it all to go to my 3 children or, grandchildren, however you want to do that then too.
Yes, and there's 2 ways, and this is also one of the chat questions, so it'll answer that. You can have a beneficiary on the brokerage account that says names your 3 children, or you can what's called retitle your brokerage account into your trust, and then it goes according to your trust. So it becomes a trust asset, and your trust says what happens to it. So there's 2 ways you can make that happen.
Okay. All right. Thank you.
You're welcome.
Okay, so Johnny had a couple of questions, and I know you just touched on one of them, but I just want to make sure we clarified. There were 2 questions from Johnny, and I think we just sort of went over one of them. Is there any advantage to making your trust the beneficiary of your life insurance? And then her second question was, you mentioned the daughter could have the assets in the trust until later. I thought the trust assets had to be dispersed in a set amount of time, like a year or 2.
Yeah. So so the first one is there an advantage to making your trust the beneficiary of your life insurance? There's not necessarily an advantage, but I recommend it. So if you have, your trust is going to distribute to 6 people and have it set up certain ways, that's how you want your life insurance to go, then yes, you should make the beneficiary of your life insurance be your trust. What you don't want to do is have your oldest child be the beneficiary of your life insurance and assume they're going to use that for everything else. That is now theirs. They don't have to do anything with it that they don't want to do. So sometimes people will name a child as the beneficiary of their life insurance and assume that child's going to use that to pay for funeral expenses, and things of that nature. And they do not have to do that, especially if there's 5 other kids that, that are involved. That one child essentially gets a windfall. So having your trust be the beneficiary of your life insurance makes everything more equal. You have your trustees. They have much more, we call them duties. That's a legal thing, like a fiduciary duty or a duty of loyalty to the beneficiaries to not misrepresent any money or misplace any money. And then, sorry, the second question was, it can stay in trust for somebody and doesn't have to be distributed out in a certain period of time. So it depends on how your trust is set up. So you can set up a trust and it goes outright to your 3 children. It's usually distributed within a year or so, or less. Frankly, in California, the shortest is 120 days after you send out notice to all the beneficiaries that there's trust. It doesn't have to be a year or 2. You can set it up to stay in trust for them. A lot of people will leave a trust for their kids so that, it's held for their health, education, maintenance, and support. So some money can be paid out until they're 25, and then at 25, they can take out a quarter of it, and then at 30, they can take out another quarter of it, and so forth. You can set it up however you'd like. There's no rules in terms of the forever and ever of your money being distributed.
Thank you.
Right, and Johnny also asked, is the successor trustee paid a percentage of the assets or an amount, and if so, about how much?
Yeah, so this is the fun answer. It's a legal term and it's a reasonable amount is what they're entitled to. It depends where you're located, what the going rate is. Usually a professional fiduciary, a bank will take 1% of the value of the estate. Sometimes people just charge an hourly rate. As long as the other beneficiaries are agreeable to it, that's really all that matters.
Okay, and
Thank you.
did that help, Johnny?
It sure did. Thank you so much.
All right, great. So here's a good one. Warren asked, where should you store your will? I know it came up before, but let's touch on that, I guess.
Yeah, I mean, if you can't store it at an attorney's office, even that's not necessarily going to be the safest place. I suggest a fireproof box, waterproof box in your home. Usually they make them look like little filing cabinets. They're fireproof and waterproof. I know, like being in Northern California, the fires that we've had, a fireproof box is not going to stop that. But that's, far and few between. It's still better than, in my eyes, a safe deposit box. Although a safe deposit box is okay if you have someone else that can have access to that after you die. So you just would want to make sure that that's set up at the bank.
So, well, Sandy Cohen had said she got a waterproof, fireproof envelope online, and she keeps all of her important papers in that envelope. Is that?
So that's great.
That's
Yeah.
good as well. So you can
Yeah.
buy that online. That's
Yeah.
something easy. Okay.
Yeah, and you just want to make sure someone knows where it is. Like, it's great to keep it safe and hide it, but you don't want to hide it from everybody. You still want somebody to be able to find it.
Right. Okay. All right. And, so Lois, I'm going to unmute you. I do see a bunch question from you here that came in, and that was basically, if you do an online will, let's say per Zoom or for belongings, do you still have to do probate? Was that your question, or you want to add to that?
Yes, because I have something very simple. Everything that I have is already with beneficiaries, the bank and my whatever I have, and I have no family except a brother. And it's very, very simple. And if I have belongings in my apartment, what do I need a will for that? I mean, what do I do with just things that are? I don't think I need a trust because I don't really have anything. There's no property or anything. I just have everything is beneficiaries, my bank accounts and whatever. It's just whatever I have in front of me in my apartment. So what do I do?
Yeah, a will is perfect for that. And it doesn't necessarily mean that it has to go to probate. I can't speak on each individual state's probate laws, but like in California, if the value of what would be going to probate, if you needed one, is a total of $166,250 or more, then a probate is required. If it's less than that, meaning if it's a bank account with 50 grand and the contents of your apartment, you don't have to go to probate.
So I could just write a list of things, like I'm here, I want this chart, little.
Yeah.
Need to go to this. Does it have to, can I just write it down and have it stick, or give it to my friends or my brother or something? Or does it have to actually be formal in a will? That's what I'm saying.
Well, okay. So then the answer to that is, if you want it to be legal, it would need to be in the format of a will and signed pursuant to the laws of your state. If you just have a list and you're not worried about your friends, anyone going to court, then a list is fine, but it's just not going to stand up in court as a legal.
Someone just came to my apartment and looked at it and said, oh, I like this or I like that. And I don't care who takes it. I just want whoever, will benefit from it to take it. Doesn't have to be something that people are going to fight over. Just a
right. Yeah. So,
formal.
Yeah, that's just the difference between the documents. One being it's a legal document and the other one is not. Doesn't mean that the one that's not legal won't work. It just depends on your situation. If you just want to make sure that your friends come take what they want out of your apartment and they deal with it themselves, then that's perfectly fine.
Does that help,
What
Lois?
happens if you don't? The other question is, I live very simply and whatever. I just have a brother who lives out of state. But if I have all my powers of attorney were with a friend who lives in New York, I live in New York, in terms of handling after you get deceased, does it have to be the brother? Or
it would be whoever you name in a will.
Do I have to, but if you don't have a will, who handles?
Then
who handles all your, when you're gone? I mean, I have everything, I have funerals done, paid for, whatever, but who actually does all this work?
Yeah, so it could be, it depends, do you have a power of attorney or a living will or a power of attorney for medical?
Gave us my power of attorney, but that's
Okay.
when you're living. But if you're deceased, what happens after, you know,
Well,
like I say, is very, very simple in my case because everything is with beneficiaries. It's just a matter of who says, okay, you come into my apartment, look at this, look at that. I mean, who does actually the formal going to the cemetery, you know, going to the funeral parlor and saying, okay, so-and-so died and what do you do? Who
Yeah.
handles?
So that's going to depend specifically on the laws of your state, but there are usually laws that have an order for who gets to do funeral arrangements or decide on cremation or organ donation or things of that nature.
And
And you,
it's written. That's what I'm saying. It's already written because I have a cemetery thing, I have a, you know,
right, but the person who signs off
Oh.
on that with the mortuary, there's laws that deal with that. And sometimes they are the person named in your power of attorney or the person named in your healthcare directive or living will. And if it's not, then it would be your next of kin. If you haven't named someone that can do that for you, it would be your next of kin. So it'd be your brother.
okay, thank you very much.
Okay, so Jeanette asked if a bank account has been a beneficiary, should it be included in a trust?
Yeah, so that's a one or the other. So it either has a beneficiary as people or it's in your trust. It can't be both.
Is that? Can you hear me?
Yeah, did you?
Okay, yeah,
I
Oh,
hear you. I think she's on mute for some reason.
yeah. Can you, let's unmute. Are we trying to unmute Jeanette? No,
Yep.
Jeanette, did that help? If you want to unmute. Okay. All right, well, we can come back if Jeanette comes back on, we can grab that again. So Sylvia had a question. Are social network accounts, email accounts, et cetera, included in digital assets?
yes, the answer to that is yes. Most accounts, like social media accounts, they have provisions for what happens if you no longer have access, either incapacity or death, and that would be in the terms and agreements that none of us read when we open an account somewhere. It's in there, and it's usually set up for their benefit. And then email would also be digital assets. So that's either something named in your trust or somebody has to open a probate to get access to those items.
Okay, and who inherits debts if there are any?
Yeah,
Okay.
so nobody typically inherits your debt. So like if you pass away and you have more debt than you do money, your money is used to pay off the debts, and each state has their own laws as to what gets paid first. So, good for me, attorneys always get paid first, your executor gets paid first, then your debts, and then anything left over goes to your beneficiaries. But if you have more debt than you do money, nobody is responsible for paying off your debt unless they've co-signed on a loan or something like that. But nothing, if you just have a $5,000 Chase credit card line and it's maxed out and you pass away and there's only $3,000 left to pay them, then Chase is the one out the money. No one else has to front that money for you.
Okay, so Janice, I see you have your hand up and you have a question here. If you already have a will in place with an attorney, can I attach a piece of paper with who I designate jewelry, et cetera, without going through my lawyer?
It depends on what your will says, but typically you would want, sometimes they will say that you can do that, sometimes they don't. So if it says you can, and it's a legal document. If it doesn't say you can, then you can do that, but it would not be legally enforceable in a court of law.
Does
Can I
that help?
ask a question?
Go ahead.
Okay. All right. I think you probably answered my question with the personal property memorandum, which would be best for me. However, I have a question. And this is crazy, but my sister-in-law has named me as her power of attorney, her medical power of attorney. However, she's a non-vaxxer.
Okay.
You're smiling, so
Yeah.
you probably have come through this.
Mhm.
She also has me as her executor split with her brother who lives out of town. I guess my question to you is, I'm concerned because if something happens to her and she has me as her medical power of attorney and I have to go out there, I don't want to, and haven't been around her now for 2 years because she's a non-vaxxer. So how do I handle this situation? Just tell her to take me off of all of this? I mean, she doesn't have many people in her life.
Yeah,
I was
mean,
married to her. I was married to her brother and he passed away 2 years ago. So
yeah, so you can, it kind of depends on how you want to handle it with her and your relationship with her. You can ask her to take you off, but you certainly are not required to act just because you're named in someone's document. So you could always wait and take a wait and see approach and see what she actually needs. I mean, doesn't mean if she needs some medical power of attorney to act for her, it doesn't mean you have to be there necessarily. So you could always just take the wait and see. And if it is something that's going to require you to travel and do something that's outside your comfort zone, you can just decline. And she probably has somebody named after you in the document. Or hopefully she does.
She has me as second.
Oh, okay.
And nobody after me. So I kind of feel badly about the situation because, you know, she's alone. And at the time I said, sure, I'll do it. But that was before COVID.
Sure.
So I'm sure you've come across this now with people.
I have people who don't know who to leave their money to now.
Right.
Because of the
issues and thoughts. And,
they have now determined that who they thought were their friends don't have the same, you know, morals, ethics, whatever that they do.
Yeah.
And they've now come to realize it. So it happens. And that's why I mean by it depends on the relationship you want to have with her. I mean, you don't want to necessarily be like, okay, take me off your documents. I don't want to help you because that, you know,
Right.
I'm sure your goal is not to hurt her feelings or ruin your own relationship, but
Absolutely.
you know, yeah. So it could be just one of those wait and sees, but there is nothing that you're bound to make a decision, you know, to act just because you're named in her document.
Okay. Thank you.
Mm-hmm.
Okay, so Warren asks, is there a flow chart that lists the things you need to put together prior to expiration, and who knows this information and where is it stored?
A flow chart of what you need to put together. I'm sure there is. I'm sure that's a Googleable graphic that you can find, and probably state specific as well. I don't necessarily have one already set up, but yeah, there are documents, probably flow charts that you can Google and find for that. And then what was the other question? What was the rest of it?
It was, well, it's really who knows the information and where is it stored. So
okay, yeah. So you just let your whoever's going to handle everything for you, or whoever's going to get everything, depending on how you have it set up. You let them know where it's stored, or provide them with copies of things.
Okay. Warren, does that help? Was that the same? Were you just trying to find out where you might find the flow chart? Does that help?
Yeah, the issue is it's such a daunting task. There's so many things. It's where do you start? And I've been to several of these seminars, and it's just getting, you know, heck with it.
Yeah.
Just die.
Right.
Let it work. Let it work itself out.
Well, there are laws that are set up for that. So if that's, you know, not something that you're concerned about, you can do that. One place you might want to start is your local county bar association. A lot of time they have senior legal services available, and they will help with low cost or no cost estate plans, wills, trusts, power of attorney, things like that. And they could help you get started on that.
Thank you.
Mm-hmm.
Okay, and Judy asks, what if you have assets in different states? What if named administrator and beneficiaries are in different states?
Yeah, so that's okay. They would just need somebody in the state that well, it depends on what the asset is, but I'm assuming it's property, because that's usually something you can't access necessarily remotely. But you would have whoever's handling a trust administration or a will administration, estate administration, they would do that via deed work, or they would have to have an attorney. If let's say I die in California and my entire estate's here, but I inherited a family home in New Jersey and I own that if it's not in my California trust, it's subject to the laws of New Jersey. So you would have to get your administrator would have to get an attorney in that state to help navigate that probate process. So it just kind of depends on each specific asset. If I had that in my California trust, that New Jersey property, then there'd be no problem. We would just take care of a couple deeds and sell the house or hand the house out to whoever it's going to, and call it a day. You don't have to necessarily deal with the courts in that state.
So may I ask a follow-up question?
Of course.
Sure.
So where would you choose to set up the trust if you have property in different states and lives in different states? Where would you choose the administrator or the trust, or even the attorney to set up a trust?
Yeah. Can I ask you a follow-up question before I answer that question?
Absolutely.
Do you split your time between two states, or do you have a resident, like a main residence in one state?
I split time between both states,
Okay.
between two different states, and property.
Okay. And do you, so you could do either one. I don't think it matters. I personally would choose the one in which you've chosen to be domiciled in, where your driver's license is at, where you file your taxes. Just to keep it cleaner, I would do that.
Okay, but you recommend if you have property in multiple states that it's all included in the one trust to keep it.
And
Okay.
that's perfectly fine. You are allowed to put property in any of the 50 states in a trust that you create in whichever state you'd like.
Okay,
There's
great.
nothing
Thank
wrong with
you.
that. Mhm.
Okay, and Rose, go ahead. I see you. And Anna, you're next. I see you there. Go ahead, Rose.
Okay.
First of all,
Oh.
who is it?
Rose is gonna ask and then we'll get right to you,
Okay,
Anna.
okay.
Go ahead, Rose.
Okay, who, do I have to tell the bank who will get the ability to use my account when I die? Or do I have to give written information to them if I don't have them listed as somebody on my account?
If you are going to fill out a beneficiary designation form, leaving the account to somebody, then you just fill out the form. They may or may not ask for contact information for that person. And then it would be that person's responsibility to provide a death certificate and notify the bank that you
Okay,
passed away.
okay. What about a vehicle?
So that would be left to somebody if there's no one else on the title with you, and you have title, meaning you don't have a loan.
Right, I have a title.
Yeah, and you're the only one on it, then that would be something in your will.
Okay,
And you just leave it to that person, and then whoever the executor of your will is would give the pink slip to them and a copy of the will, and they would go to DMV, or anybody that maybe handles DMV services. Like, for example, I like to tell people to use AAA if that's an option for you, because they do a lot of DMV services, and who wants to go to the DMV. But they can fill out the forms at DMV and get that title transferred over. As long as
okay,
there's no probate, of course.
okay. There shouldn't be. What about organ donation that I have listed on my driver's license?
Yeah, so the registration with Donate Life with your driver's license supersedes everything unless you have a written revocation of that in your advanced healthcare directive. So they will go off your driver's license. So if your living will or your healthcare directive, you check no on the no organ donation box, but your license has the pink dot on it, they're going to go off your license unless there's specific language revoking that organ donation that you granted on your driver's license.
Okay.
Of course, there are rules in every state as to whether or not anybody can donate. You know, you might just be disqualified in general after a certain age or after any type of diagnosis, they might disqualify you. So that may just become moot anyways.
All right,
Hello?
thank you.
I'm unmuted. I had a question about,
Can I?
Oh, hold on one
maybe.
second. Who's
I'm
that,
Alex.
Alex? Okay,
Yeah.
Alex, hang on one second. We're just gonna get to Anna. Rose, did that help?
Yes,
Okay.
thank you.
Okay, all right, go ahead, Anna.
But I would like to find out, how can I make my attorney, who has the power of attorney, my executor?
Yeah, so to make someone your executor, you just would create a will and you name them the executor in your will.
In the will. Okay,
In the
thank
will,
you.
yeah. Mhm.
Okay, Alex, you're on. Go ahead. If you want to unmute.
okay, can you hear me now?
Yeah, go ahead.
Yeah, about property, if there's still a mortgage on your property, or you have a home equity line when you pass away, can those mortgages be transferred to your inheritors? Or
Yes.
do they have to be paid off before, or how does that work?
It's going to depend on the actual lender. Typically, what they are allowed to do is restate the mortgage in someone else's name. So if your kids inherit, they also inherit the mortgage, but they're going to inherit it on the exact same terms that you had it. So if they want anything better, they'll have to refinance it, and then they would have to qualify on their own, credit and income and debt. But typically, you inherit a house with the mortgage, and they just keep paying the mortgage.
I see. So any debt, so if there's a lien against the house or anything, that goes with the property. They don't inherit the lien. They can just keep paying the mortgage, and the lien is when the property is sold, or is the lien against me, not against the property?
It depends on what the lien is. Sometimes what can happen is they typically would put a lien against the house because it's guaranteed that they'll get paid eventually, meaning you can't sell the house and you can't refinance the house without paying the lien off. But also after somebody dies, the creditors are usually required to get notification, and they have 1 year from the date of death typically to file a creditor's claim, or they would open their own probate if there was no probate. So they have the ability to force the payment of their lien. And then one of the things that doesn't go with the house is a reverse mortgage. So a reverse mortgage doesn't mean that your child inherits the house and then gets to just keep that reverse mortgage sitting on the house until they sell it. That has to be paid off.
Oh, that's very good. Thank you so much for letting me butt in here. Thank
So
you.
you're welcome.
No problem. Thanks. All right. Save the best for last. Jen, go ahead. You've been very patient there. Go ahead.
You
If
know what? But
Got
all
your
of my
question?
questions were answered. It actually had to do a lot with the debt. That I was curious with credit cards and mortgages and all that stuff. So I just forgot to take my hand down, but I was interested in that, what happened with all those things, because it's something I never learned about. You were excellent, by the way. I learned a lot. Thank you.
Yes. Oh, Barbara Waldron, go ahead. If you want to unmute. Yeah, go ahead.
You mentioned something about a reverse mortgage. The children or the child would have to pay it off. If they didn't have the money to pay it all off, what happens is, would they get a second mortgage on that reverse mortgage, or how does that work?
Yeah, they would either refinance it with a traditional mortgage, and just on their own credit and income, they could refinance it. And then the reverse mortgage goes away, then they just have a regular mortgage on it, or they would have to sell.
Okay, thank you.
Mhm.
Yes.